I know I've made mention of this a lot in a bunch of my videos here, but I think it's time enough to do a dedicated video on what I think we should be doing with Section 230, whether we need to reform it, what we have on the table right now from President Trump and the Department of Justice, as well as the opinion that Justice Clarence Thomas, that is, put forward last week, and the origins of Section 230. So we're going to go ahead and start by taking a look at what the Justice Department has on tap right here. This came in right at the end of September, and it's currently just on the table. I don't know, it's very comprehensive, but it's not exactly what I'm looking for, but I want you guys to have all the information out there first. So the department identified 4 areas ripe for reform. Incentivizing online platforms to address illicit content. The first category of potential reforms is aimed at incentivizing platforms to address the growing amount of illicit content online while preserving the core of Section 230's immunity for defamation. A Bad Samaritan carve-out. First, the department proposes denying Section 230 immunity to truly bad actors. The title of Section 230's immunity provisions, protection for Good Samaritan, blocking off and screening of offensive materials, makes clear that Section 230 immunity is meant to incentivize and protect responsible online platforms. It therefore makes little sense to immunize for civil liability an online platform that purposefully facilitates or solicits third-party content or activity that would violate federal criminal law. So what that means is they would be able to, if this reform from the Justice Department was passed through, it would still make the publishers or the platforms, however they're going to be referred to in the future, as responsible to maintain their comment section, and therefore their content itself would need to adhere to the bounds of criminal law, which I think is probably the best place for it to end. I don't think it really needs to extend any further than that, but of course they provide a little bit more desire for their reformation efforts. Carve-outs for child abuse, terrorism, and cyber stalking. Well, I think that's probably covered by federal criminal law, but let's take a look. Second, the department proposes exempting for immunity-specific categories or of claims that address particularly egregious content. 1. Child exploitation and sexual abuse. I think that's already a federal law. You're not allowed to do that. Terrorism and cyber stalking. Now, those are very vague terms. What do you mean by that? These targeted carve-outs would halt the overexpansion of Section 230 immunity and enable victims to seek civil redress in causes of action far afield from the original purpose of the statute. Now, this is one of those slippery slope arguments. What exactly is terrorism? We all have a picture in our head of what terrorism looks like. It looks like 9/11. It looks like beheadings in the street. But if we start warping what those definitions means, all of a sudden, if you disagree with anybody on the left, you are a white supremacist. So you can see where that kind of slippery slope argument comes in with terrorism and with cyberstalking. Now, cyberstalking specifically, how do you draw the line? What is the point where you cross from being a troll and then cross into the stalking territory? That's not really terribly defined there, and I don't think you should be inculcating anybody. There is a block feature, there are mute features for a reason, and if you can't handle it overall, you probably shouldn't be on these platforms. That's just my opinion, though. Case-specific carve-outs for actual knowledge or court judgments. Third, the department supports reforms to make clear that Section 230 immunity does not apply in a specific case where a platform had actual knowledge or notice that the third-party content at issue violated federal criminal law, or where the platform was provided with a court judgment that content is unlawful in any respect. Just once again, another redundant clause. Just make it so that these platforms have to get rid of illegal content, shit that is not protected by First Amendment free speech rights. I think that's pretty fair. So once again, they're just introducing these little weasel words that actors of bad faith can come in and exploit, which is why we're in the situation we are right now. Clarifying federal government enforcement capabilities to address unlawful content. A second category reform would increase the ability of the government to protect citizens from harmful and illicit content. just need them to... I'll continue. These reforms would make clear the immunity provided by Section 230 does not apply to civil enforcement actions brought by the federal government. Civil enforcement by the federal government is an important complement to criminal prosecution. Now, what that means, to the best of my knowledge, is that the federal government would be looking after these big tech giants because they can be headquartered in California, and then they could have satellite locations in different states or different other countries throughout the world, but they would still be beholden to U.S. federal law. They couldn't take advantage of different loopholes that exist in different states. They would be beholden to one uniform law, which I do appreciate. I like that. And then the final point that they bring up that also has 3 additional clauses: promoting open discourse and greater transparency. It sounds good, but let's see what it actually says. A 4th category of potential reforms is intended to clarify the text and original purpose of the statute in order to promote free speech and open discourse online and encourage greater transparency between platforms and users, which is really what this section of the criminal code needs overriding for in the worst way, because it was put into practice in 1996. Y'all remember the internet in 1996? A lot of GeoCities websites, a lot of Angel Fire websites. It looks nothing like it does today. Twitter was merely a glint in Jack Dorsey's eye. Mark Zuckerberg was too busy not getting laid in high school in 1996. The world has changed immensely in these past 24 years. Holy fuck, 24 years? Can you believe that? That's amazing. Replace vague terminology in Section 2 of Section 230, so the subclause of Section 230, which is also what they're trying to do with this reformation. So that's why I'm not exactly a big fan of it. There's a lot of little inroads for the unfair actors, at least what I can tell. What do I know? I just have a exercise physiology degree and a microphone. I am a goddamn expert. This microphone means it. First, the department supports replacing the vague catch-all, otherwise objectionable language in Section 230, Section 2, with unlawful and promotes terrorism. Why can't we just have unlawful? I don't like adding additional verbiage in there that can be taken advantage of. This reform would focus the broad blanket immunity for content moderation decisions on the core objections of Section 230 to reduce online content harmful to children. Oh, won't somebody please think of the children? While limiting a platform's ability to remove content arbitrarily or in ways inconsistent with its terms of service simply by deeming it objectionable. Exactly, and that's the entire point of wanting to reform 230. When Oath Keepers, Patriot Prayer, right-wing individuals in general get fucking blasted off of all these platforms, and Antifa can continue to dox, organize, and harass online. And I'm not talking like, oh, you hurt my feelings. I'm talking about organized campaigns where personal information is put out there and harassment on multiple other platforms exists. So just because they like to organize, Antifa does most on Twitter, doesn't mean that if somebody has a dissenting opinion, they can't go onto their Facebook account, they can't go onto their LinkedIn account, they can't go into their comment section on their YouTube page. You might think that this is hyperbolic, but this is exactly what they do. Provide definition of good faith. Absolutely, whenever we're clearing something up, that is a good way to reform things. Second, the department proposes adding a statutory definition of good faith, which would limit immunity for content moderation decisions to those done in accordance with plain and particular terms of service and accompanied by a reasonable explanation, unless such notice would impede law enforcement or risk imminent harm to others. Clarifying the meaning of good faith should encourage platforms to be more transparent and accountable to their users, rather than hide behind blanket Section 230 protections. I don't know what Section 260 is, and maybe it needs reform, but that's another video for another day. So yes, we kind of understand whenever you're arguing with somebody in good faith, that means that you guys are wanting to find solutions to a problem. Now, if you give that to a publisher or a platform, they can obfuscate what good faith means because, oh, we're just trying to protect everybody, therefore this mean person needs to get off the platform. We are making it illegal illegal on their platform to misgender somebody, like what Twitter does, or because this story is uncorroborated with Hunter Biden's emails. If you share it, we will lock you out of your account, like James Woods, Team Trump, Kayleigh McEnany, Jack Posobiec, and many other smaller accounts as well. Because that could have been hurtful to one party, we're just exercising our good faith in getting rid of those harmful, evil people. That's why it should just be unlawful speech or content that has to be removed. The rest of it has to be at the discretion of the users. And then we get down to the final part here, which will lead into the next story. Explicitly overrules Stratton Oakmont to avoid moderator's dilemma. Third, the department proposes clarifying that a platform's removal of content pursuant to Section 230, subsection 2C, or consistent with its terms of service does not, on its own, render the platform a publisher or speaker for all other content on its service. And that's why 230 came about, is because it was determining what is a publisher and what is a platform. A publisher has an editor and a curator, acts as the same thing. So places like the New York Post, the New York Times, all your major newspapers are liable for what they put on their site because it is moderated content, and therefore they have freedom of the press provisions provided by the Constitution. Whereas a platform does not need to have those same protections because they are apparently not supposed to be moderating the content because it is merely a platform. Have it out there into the public square. And because all of these provisions in Section 230 have been wildly taken advantage of in the past decade or so, yeah, I think that seems about right for a time frame. Section 230 needs to be drastically overhauled. I like a lot of the points that they're bringing up here, because it is an outdated bill that was originally just supposed to be for forums, for actual news websites. They could not have prophesized the rise of social media. Hence, the most current and up-to-date reference that they have in 230 is for the company Stratton Oakmont. Now, if you guys are familiar with The Wolf of Wall Street, he is the exact reason, Jordan Belfort is the exact reason 230 came into fruition, which I didn't know, and it was learning that fact was the reason why we're doing this video here today. I know we got to use a Slate article, but at least they kind of spice it up and they keep fairly straight to the story. How the Wolf of Wall Street created the internet. Okay, I immediately regret what I just said. In a suit to protect his company's reputation from angry online commentators. The Wolf of Wall Street, Martin Scorsese's splashy 3-hour portrait of financial excess, has produced a surprising amount of internet controversy. Defensive interviews from Leonardo DiCaprio, a scorched earth open letter from the daughter of a convicted traitor, and the usual outlandish and bloodthirsty commentary that always peppers online public forums, from the desire to airstrike a Wall Street movie theater or cue the guillotines for bankers. Oh my god, these fucking Occupy people just never fucking give it up now, do they? To the typical declarations that theft is routine at Goldman Sachs and the bankers are sociopaths. Oh, nothing about the Jews. Fucking morons. We take the cacophony of the internet for granted, but 2 decades ago, it wasn't obvious that it would develop this way. Exactly. It turns out that we have a real Wolf of Wall Street to thank, in part for the internet that we've got. The rule that allows for our rollicking, easily scandalized internet would not be the same without Jordan Belfort, a convicted stockbroker who is the model for DiCaprio's character. That's exactly who he is. Fucking Slate, they must have a word count in all their articles. And his felonious firm, Stratton Oakmont. In the mid-1990s, Stratton Oakmont started the lawsuit that led to much of the basic legal framework that governs internet content. Were it not for that lawsuit, the strange ruling and strong backlash it created, the internet as we know it might be a very different place. Traditionally, liability for wrongdoing can be extended beyond the parties immediately involved. Employers can be liable for accidents caused by their employees. Bartenders can be liable for serving customers who get behind the wheel. And in the words of a publisher, can be held liable for the materials that they produce on their sites. In the early days of the internet, it was unclear whether and how a variety of new online services, the first chat rooms, message boards, aggregators, and the like, were responsible for the content produced by their third-party users. Possible lawyerly analogies abounded. So it created a unforeseen situation, like they were saying earlier there. Like, okay, these platforms that the people are using, the AOL chat rooms, the MSN messengers, should they be held to account for the fact that they are merely providing a service that the users may or may not be engaging in illicit activities in? Just because they presented you the framework, it's like, okay, if somebody sells you a rope, and are you going to be setting up a tent, or are you going to be asphyxiating puppies? Like, there's a big gap there, and should the hardware store be held accountable for the fact that you're going to use that garden hose to kill yourself in your garage? That's the same kind of conundrum that MSN, AOL, and the like faced in the late 90s, early 2000s. These questions were pressing because of the sheer number of users generating online content, even if only a small percentage of them do illegal things, posting non-consensual nude pictures or spreading intentionally malicious lies. A small percentage of millions of users add up to make a lot of that liability. That liability would give internet service providers and websites pause for letting their users post and publish freely. And here's where we kick off. Enter Stratton Oakmont. In the mid-1990s, the brokerage house and its then president, Danny Porish, sued Prodigy Internet Services over a series of anonymous and allegedly libelous postings on Prodigy's Money Talk computer bulletin board. Among other things, the acrimonious comments stated that Porish was a soon-to-be-proven criminal and Stratton Oakmont was a cult of brokers who either lie for a living or get fired. The New York Supreme Court decided that Prodigy should be treated as a publisher of the anonymous comments. The court was a little fuzzy on the reasoning, but emphasized that Prodigy was a self-styled, family-oriented computer network that had actively edited a portion of the voluminous content it received. The basic idea seemed to be that because I don't know why that's so hard to say. Prodigy edited some of its user-generated content, it made itself responsible for all of that content. That meant Prodigy could have had to pay damages to Stratton Oakmont, hence the creation of Section 230, which sought to undo Stratton Oakmont's decision by guaranteeing that no provider or user of the interactive computer service shall be treated as a publisher or speaker of any information provided by the another information content provider. Section 230 is a strong provision and it has gotten a lot stronger in the hands of the courts. Judge J. Harvey Wilkinson III of the 4th U.S. Circuit Court of Appeals, for example, has ruled that Section 230 frees internet service providers of both publisher and distributor liabilities, which means that they don't even have an obligation to take down defamatory content. So it's weird how Jordan Belfort can have such wide-ranging effect on, well, something that everybody uses every single day. A man who was a convicted felon via exploiting the stock market created the provisions that were supposed to create a free and open internet, and it's a case that's still relevant 24 years later. Very few rulings have had such a significant impact on everybody's day-to-day life. But I've shown you the history of 230. I've showed you what the Justice Department wants to do with it. But now let's go up to the Supreme Court, where we have Clarence Thomas wants to reel in Section 230. And when it comes to opinions, you know what, Clarence Thomas at least wants to put his out there, and he's quite an authority on cases like this, so we should at least take a look at what he has to say. The long-standing but now hotly contested law that keeps online platforms from being held liable for what users post should be narrowed, conservative Supreme Court Justice Clarence Thomas wrote Tuesday. Section 230 of the Communications Decency Act is a growing target of bipartisan ire. Thomas, arguably the most conservative member of the Supreme Court, is laying down a marker as a likely confirmation of Amy Coney Barrett looks set to tip the High Court further right. Or maybe they're just going to interpret a law based on what the Constitution's after, and if being a constitutionalist is a right-wing position, then fuck it, the right is all about the truth, I suppose. Whatever. Deal with it. Thomas wrote about Section 230 in a filing following the court's decision not to hear the Section 230 related case, Malware Bytes Incorporated versus Enigma Software Group. Thomas said his fellow justices were right to pass on the case, which centered on whether Malware Bytes, an internet security company, could be held liable for what Enigma Software said was a wrong designation of its products as malware. But he said it would welcome the chance to scale back Section 230 from the bench, through a different case. Extending Section 230 immunity beyond the natural reading of the text can have serious consequences, Thomas wrote, adding that when the right case comes to the court, it would behoove the justices to consider narrowing the reading of the law. Exactly. Clarification and specificity. Thomas wrote that internet companies have been granted sweeping protection, which they have, and that courts are reading more comprehensive immunity into Section 230 than was intended. And that's what happens when you put in weasel words into anything out there. If you aren't specific, if you aren't pointed with your speech, the unfair actors will find a way in, and eventually you lose control. Internet companies and law authors have long argued that the purpose of Section 230 was to allow companies to moderate online content and remove material as they see fit, and that companies like Facebook, Google, Twitter, and Yelp couldn't exist in their current form without the law, and we'd be better off if they didn't exist in their current form. Those defenses have a shrinking constituency in Washington. Republicans, including President Donald Trump, now argue the law acts as a license for tech platforms to censor conservative views. I think we see that in action now, don't we? There's little to no evidence that these claims of anti-conservative bias, which the platforms deny. Is Axios really sticking their head this far in the sand? Or I guess they just want to adhere to their fellow brethren in the mainstream media. Fair enough. Democrats, including Joe Biden, have said Congress should revisit Section 230 to make tech firms more accountable for misinformation and hate speech. Now see what they're trying to do here. Republicans, including President Donald Trump, now argue the law acts as a license for tech platforms to censor conservative views, which they are doing, which they only get rid of people on their platforms when they espouse ideologies that are right of center. So Trump and fellow Republicans are making a pointed case that no, these tech giants are using 230 as a means to cover up for the fact that they have a pronounced liberal bias, whereas Democrats and Biden just want them to be more accountable for misinformation and hate speech. If it's them defining hate speech, if it's them defining misinformation, I don't want that future. Nobody wants that future, because then the internet looks a lot like what China has right now, and you guys don't want that. So to wrap it up, a number of Section 230 related bills have circulated in Congress in the past year. None stand a chance of passing before 2021, because the Congress is too busy trying to impeach Donald Trump or pass a bunch of fucking bonkers Green New Deal-esque proposals, or I don't know, bicker amongst one another. And even if it did pass through the House, it would never make it through the Senate, because it is Senate-controlled Republicans, or Republicans control the Senate, and the House right now, we're just in front of the election, is controlled by the Democrats. So it would take an extraordinary effort and many more good faith actors than what are currently elected out there. But I thought that was a pretty good background into what I think we need for Section 230, what the Justice Department wants for 230, the history of it, and a very well-respected Supreme Court Justice in Clarence Thomas has to say on the matter. Hopefully you guys are a little bit more educated on this. It's something that affects everybody every single day, and I want you guys to at least be informed on the topics. If you'd like to discuss it further in the comment section down below, I would love to hear everything that you guys have to say about it. I thank you very much for the gift of your time. I've been Don Consuelo. I want you guys to follow your gut and get after it. Take care, everyone.